Hello, and welcome to the DRBF webinar on dispute boards in MENA, Debunking the Misconceptions. We're very pleased that you can join us today. Please take a moment to notice in the bottom of your screen, there is a button for Q&A. We would love for you to include your questions in that field, and our panelists will address them at the end of the webinar. We should have time to answer all of the questions. So please be very complete in your question. If you have something that you would like addressed by a specific panelist, you can include their name. Or if you want to reference one of the topics that's being addressed or something new, we'll be happy to make sure that it's covered before the end of our webinar. Today we have a number of very experienced dispute board practitioners who are available to talk with us about some of the misconceptions in the region. First, I'd like to introduce Tariq Hamid. He is a construction manager and arbitrator with DAR for engineering contracts in Egypt. We also have Walid El Nemer. He is an engineer, contracts director, and consultant with Hill Engineering in Egypt. And we have Yasmin Chutnell, who is an attorney based in Istanbul and also a member of the DRBF's Region 2 Board of Directors for the MENA region. We have another panelist who we hope will be joining us shortly, Ahmed Gula. He's with Senwan Consultancy in Libya. And unfortunately, he is having a few technical difficulties today. So we will go ahead and proceed, and hopefully he'll be able to join us, and we'll circle back to his presentation. There is a chat field, and you are welcome to include some comments throughout the presentation. But again, as a reminder, please use the Q&A field for any specific questions that you'd like the panelists to address. So now I'm going to share my screen to start a presentation, and we will begin with debunking some of the common misperceptions about dispute boards. We will start with misconception number 2 with Walid. It's all yours.
Thank you, Anne. Now, misconception number 2 is that dispute boards may sometimes ignore the contract provisions and impose their ideas of fairness and equity. Now, I'd like to start with a personal experience and a note that actually this misconception is close to my heart. I have to admit that from my first dispute board experience, as I was one of the parties to the dispute, I was actually, because my experience is basically as Anne mentioned in Hill International, I work in contract management, so I was representing an owner in this first dispute board experience, and we had a referral. And that referral, basically, one of the claims that the contractor presented was regarding a time extension claim. And in the contract, the time extension, any extension of time had to follow a certain delay analysis method. And the contract clearly stated that if this delay analysis method is not followed, then the claim would not be accepted. So from the owner's side, we were confident that we made a good case, backed up by the contract, and we were actually very shocked that the dispute board put that aside and did not take it into account in their decision. And not only that, but in future referrals in that high profile project, they mentioned explicitly that the dispute boards will rule according to fairness. So actually, that first experience, as I mentioned, is close to my heart, and because I was a firm believer in this misconception in the beginning, and it made me actually an anti-dispute board, advocate. But that quickly changed, and for the same, also from the basis of experience, as I'm going to mention in a minute. So the second point I want to go to right now is the issue of So what does the DRBF say about this misconception? So the DRBF has a manual, as we can see in the next slide. This manual has guidelines for dispute boards. And in this manual in 2000, there's this new edition in 2019. And if we can go to the next slide, yes, this is the 2019 edition of the manual. And it's the guide to best practices and procedures for dispute boards. And this is available for free on the DRBF website. So if we go to the next slide, we'll find that prior to the 2019 edition, there was a section 1.5 in the manual that addressed the concepts, the concerns. It's called the concerns for dispute boards. What the concerns we're addressing today are just three of the concerns that are addressed in this prior edition of the manual. And there are other misconceptions, much more misconceptions that are addressed in the manual. But if we look at this slide here, this is from the previous edition, is item 1.5.2 of the manual that talks about the dispute boards ignoring the contract provisions and imposing their perceptions of fairness and equity. And if you see this first underlined point, it says clearly that it is not the DRB's prerogative. So here, just as a note, DRB, the manual was addressing the dispute review boards that provide recommendations. However, this is equally applicable to dispute adjudication boards, as in the FIDIC contract or any kinds of dispute boards, that it is not their prerogative to substitute their own ideas of fairness and equity for the provisions of the contract. So the DRBF is very clear in that this, although this may be practiced, however, this is not proper dispute board practice and conduct. So, and actually the DRBF goes further, and this is the second point, to say in the second paragraph that any member who is persistently ignores the contract provisions and rules with, say, concepts of fairness and equity, if we go to the next slide, Anne. So if any member who does that, and actually you've seen this in the second paragraph, this member should be terminated as provided for in the three-party DRB agreement. So what this is actually, if you can see, this is a very, very serious point that the DRBF manual is making, is that not only is it discouraged, actually this member should be terminated. And of course, that of course is, it would be very difficult actually to implement in practice, because if a member rules with concepts of fairness and equity, for example, and disregards the contract provisions, one of the parties is going to be happy, of course. So in that case, and as we all know that a dispute board member cannot be terminated without the joint agreement of both parties. So therefore, one party would be happy, so it would not agree to this termination. So it would not really take place. However, the point here is that the DRBF manual clearly discourages this kind of practice, and even leading to a recommendation to terminate this member if possible. And the reason for this really is that we have to know that the dispute boards are creations of the creatures of the contract. So accordingly, they have to rule or determine or recommend according to the contract provisions, and they cannot set that aside, because these are the provisions that the parties who appointed the dispute board agreed to. So this is probably why the DRBF takes a very firm stance on this. The third point, which I won't elaborate on much, is that if there's a well-reasoned recommendation or decision by the dispute board, that can minimize this practice of resorting to fairness and equity and disregarding the contract provisions. But this actually can take on a webinar of its own merit. That's another close subject to my heart, but I will defer this to another time. So if you go to the next slide. If we go to the next slide, we'll find that the DRBF has a code of ethical conduct. And this code of ethical conduct is actually, if we can see in the next slide, you find in the 2019 manual that I mentioned, there is a clear provision in that manual that any dispute board members must comply with the contract provisions when it comes to procedures. so as you can see here, the applicable, any procedures or meetings or hearings must be conducted in accordance with the applicable contract provisions. So this is one point. More notably, the second point, that dispute board recommendations and decisions must be made expeditiously on the basis of the provisions of the contract, the applicable law, and the facts. So again, there's an emphasis as a code of conduct that the contract provisions must be adhered to, and not just vague principles of fairness and equity. So this is, the DRBF is very clear on this. Now, if you go to the next slide and we go to the next point, we'll find that, okay, so after discussing the DRBF manual, so are we really missing the point? Because say a dispute board member or a dispute board rules with the concepts of fairness and equity, and they do not rule with the contract provisions. Let's remember the main objective of a dispute board. The dispute board is in place so that as a project is ongoing, these are a group of experts that the parties have appointed willingly, who are there to adjudicate or recommend on disputes as they arise on the project. So, and the reason for this is that we can, a dispute arises, it is decided upon, or a recommendation is presented, and then we move along so that we can avoid unnecessary costs and unnecessary delays. And this third point, actually, as I mentioned in the beginning, I was an anti-dispute board member, and this point alone made me very pro-dispute board, because I have seen and continue to see until this day a lot of projects that are delayed beyond reason. They can even be delayed twice or 3 times their original duration. And it's really one of the main reasons is because there are a lot of disputes that just go unresolved. And because there's a lack of a dispute board there in the project. So we have to learn to agree to disagree, and then we have to go to what's in the best interest of the project. So this is really a very important point. And we always have to think of this objective. Why is the dispute board there in the first place? The fourth and last point that I want to talk about is really specific to the MENA region, and it's the concepts of good faith and equity in the civil law jurisdictions of the MENA region. So as we've mentioned, a dispute board ruling with the concepts of fairness and disregarding the contract provisions is definitely discouraged. It's definitely it's definitely against the code of ethical conduct for the DRBF, but is it really negative? I don't think it's negative because let's look at what the civil code provisions say. Of course, since I practice in Egypt, I will refer to the Egyptian civil code, which formed the basis for a lot of the civil codes in the region. So if you go to the next slide, we look at Article 148 of the Egyptian Civil Code. And this Article 148 actually is comprised of 2 paragraphs. So the first paragraph, as we can see here, it says that the contract must be performed in accordance with its contents. So these are the contract terms and conditions, and in compliance with the requirements of good faith. So good faith is there hand in hand with the contract provisions. It's not just the express words of the contract that matter. So of course, one might ask, so what is good faith? What is the definition of good faith? Actually, there is no definition in the code. And of course, for all those common law practitioners, this might seem very vague and uncertain. However, let's look at the second paragraph. If this weren't enough, not only is good faith a sequel to the contract, but also there's a concept, of course, there's the law, there's usage, which is custom, and here you can see equity. So fairness plays an integral role for managing contracts or understanding contracts or practicing contract management. And therefore, if a dispute board resorts to the concepts of fairness and equity and disregards the contract provisions, then we should take this to mean that this is probably like a check of what might happen if the dispute board goes to arbitration. So if the dispute goes to arbitration. So if the dispute goes to arbitration, the council of the parties will definitely resort to this provision in the law, and the arbitrators might very well take this into consideration. So the parties should understand that this is like a check as to what might happen in arbitration, and therefore this might result in the parties trying to settle amicably prior to this dispute going to arbitration. So with that, I thank you very much for your attention, and over to you, Anne.
Thank you very much, Waleed. That was a great presentation. I'm pleased to announce that Mohamed Gula has been able to join. So I'm just going to click back to the start of our presentation so he can cover the topics on the first misconception, which some folks have expressed about dispute boards, and that's that they do not add value. So Mohamed, if you can take off your mute, welcome to the webinar. And take it away.
Thank you, Anne. Thank you. This is a great webinar. Actually, it's been done on time. Value. It's always related to the cost of the and what is the value against that cost. So, what is exactly the cost of the DB? From statistics that DRBF has done, we found that the average cost is 0.15% of the final construction contract cost. That's including an average of 4 dispute recommendations or hearing and decisions. This is when you consider it, it's a very minimum amount of money comparing to what DB can add as a value to the project. Even though we have a cost, but this cost is, can be applied by the contractors in their bidding. So they are already counting for it, and they are already putting a sort of a factor that is being used in the budget for the project. This is easy, can be done easily because we can quantify the DB expenses. We know how many DB members we have and how much they cost. We can always understand what is the regular schedule of the activities that will be adopted, so we know how much the visit will cost as well. And if there is a cost of dispute hearing, we have to allow for it for 1 or 2 or maximum 4 as an average, and in total, and as the statistics has given us. This is, of course, when we do it in the contract and in the bidding stage, the contractors, they don't counter or they don't actually put any allowance for litigation costs that might happen, and this will always have a competitive bids submitted to the owner. Please, Anne, can you go to the second slide? So, what is the added value of the DBs? We have 2 concepts. One of them is project-wise. The most added value is protection to the project. So we understand that when we have a DB, we are protecting our project from getting terminated, from getting delayed for no reason, getting disturbed because of frivolous claim or non-consistency between the parties. There is a real-time assessment that can be gained by having DB on board. So our assessments, and there's always somebody who can guide us to what is exactly the real affected time. We improve standards as well with the DB because we implement a lot of professional methodology and following up boards and doing meetings. During the visits, the reporting, so we do improve a lot of standards that are being adopted in the project management. It provides clarity. So when there is a DB, we are clear about our liabilities, about our rights, if there is something that we should claim for or not. So there's always a sort of clarity that is being built within the project partners during the project implementation. And the most important thing, it influences the good performance of the parties. Every party will try in front of the DB to perform in a good manner, in a way that to make sure that they are working for the benefit of the project, for the success of the project, and for the benefit of both parties. The second or the other issue that is can be considered as an added value is a contract-wise. Please turn the slide, Anne. So contract-wise, having DB on board, it facilitates cooperation and working relations and eliminates tension. That's usually something that is we face in the project. Is the tension between the parties. When if there is a claim, the first claim raised from a party to the other, you will find a lot of non-comfortable relation started to happen, and with the DB we do eliminate that. It's proactively they help avoid conflicts developing because they attend meetings, they have site visits, and whenever they see something that could come up as an obstacle later on, or maybe escalate to be a problem and then a claim, they do point it out to the parties and try to give solutions to how to solve it. They minimize accumulation of claims because if there's a claim, it's immediately looked at by the engineer, and then the DB themselves they can review it without having it delayed, not answered to. Frivolous claims are avoided. That's the best thing happens when the DB is on, because if there is no DB, you'll find the contractor or the owner and the employer, they're just giving a claim, and the claim they try to see to push for sort of a confusion to the other party so that they gain something out of their claims. They do give us a temporarily binding decision at an early stage, so we can know easily how we should proceed. They diffuse the problem. DB they go for a win-win situation, and that is the best thing that can happen in a project. Like Mr. Walid has said, it is to the benefit of the parties that they do a settlement agreement based on a DB decision. Yeah, can we turn on the slide again? So why a DB decision is favorable? I think Walid has given some highlight on that. Decision given by a panel which is composed by independent and impartial third parties who know our industry and difficulties as a company may face during the execution of a construction of a project. So we are relying on talent people, and we are relying on professional and technical people who can easily tackle our problems. They give the parties a reasonable opportunity to present their case and respond. The members become familiar with the project, so they remain up to date. They visit the site, they meet with the parties, they report to the parties, and they review the performance. So it is they are part of the project. They are like a stakeholder in the project who can influence the progress of it and the completion of it in the right way. They can quickly assist the parties either by issuing a decision or also providing an informal assistance if asked to. The last slide, please, Anne. So we said that there is a cost by having a DB, but there's also a cost saving that we have to look at. The cost saving, it is when we eliminate the arbitration or litigation. That's a big cost of getting. Especially with having a DB decision, we are reducing the cost of establishing facts due to the DB's proximity to the events. So they know everything. I don't have to come up with the new documents and to try to build up my case, which happens in the arbitration and then goes without with a lot of cost. It eliminates the need to reconfigure the documents and reduce the conditions that led to the problems, which is usually done during arbitration proceeding. The other saving, it's when we adopt the procedure, we avoid unnecessary delay and we avoid unnecessary expense. And that's by resolving the dispute in 84 days only, and which is much quicker than local courts or arbitration proceedings, which means it's a lot of lawyers and a lot of people that you have to implement to use it in litigation or arbitration, that you are getting rid of all that cost by having an 84 days decision by the DB. Thank you. This is what I wanted to share with you today, and I hope that you enjoy it.
Very good, thank you. We did have a couple of questions come in during your presentation, and if it's okay, I'd like to go ahead and bring two forward for you to comment on.
Okay.
One is about the standard or average fees for dispute board members in the MENA region. And then the second one, also related to cost, is whether you feel there are any hidden costs of a dispute board, and if so, if you think they are significant. So, Mohammed, would you mind commenting on those two issues, standard rates for dispute board members in the MENA region, and then any hidden costs that might occur with the dispute board?
The standard rates, if they are FDIC listed, then they have a FDIC rate, which is very high. If they are not FDIC listed, then it depends on the country that you are in. Actually, it's about the hourly rate or the day rate that is used within the country itself. So it varies from country to a country, but it is usually in the range of $500 per day. That is the range that we are facing in the MENA region. With the other issue, if there is a significant hidden cost, nothing that I can see, because it is straightforward procedure. You can see it from day one. From day one, when you appoint the DB, you know how much it's going to cost you, because the members, you know how much their rate, and you can always predict how many recommendations or hearing or dispute that can be called for, and that is the cost of it always is manageable. You can control it with the members, and you can always agree on different ways of minimizing cost.
Very good. Thank you so much. I did want to just share a comment from one of the attendees. He notes that one big cost saving of a DB is the time and aggravation saved to get guidance early on the matters that occur on the project. So I thought that was an excellent point, and I wanted to share that
That's
as
true.
well. I think everyone's experienced not only time delays, but that classic word he used, aggravation. So now I'm going to move ahead back to our third misconception of the day, which will be handled by Tarek Hamid. So your turn is up. I think your mute is on, Tarek, if you wouldn't mind.
Good afternoon to all. Since we are talking about the subject of this webinar is misconceptions, I will start with a saying that judging something is a branch of its perception. This means that to judge something, such judgment will be correct to the extent its perception is. And I can recall when some new approaches or some new tools are used in the industry, in the region, like FDIC. And FDIC tests started to be used in the region. There was the same misconception that FDIC favors contractors. And when arbitration was first introduced to the industry in the region, it was almost said that arbitration awards favor contractors. Actually, this is not the case, because now FDIC and arbitration are used heavily in the industry in the region, and this conception has gone. No one can say now in the region that FDIC or arbitration awards favor contractors. So this applies equally to the dispute boards. I believe that since this is a new approach in the industry, this misconception may exist. However, in the following slides, we will see that this is a mere misconception. To answer that question, do dispute boards favor contractors? The definite answer is no. No, the dispute boards do not favor contractors. Actually, in dispute boards, favors, if at all, it favors something, it favors the project, it favors the interest of the overall project. And it does, the DB do this in the context of the contract. They strictly follow the contract, they strictly apply the contract provisions and conditions to favor the project. One can say that, but what the cause of such misconception? Why it's always said that dispute boards favor contractors? I can think one reason, simply because in construction projects, most of the claims, if not all claims, are usually raised by the contractor. It's a rare case when the employer raises a claim. So given that most of the claims are raised by the contractor, this could be the source of such misconception. However, if we turn to the process itself, we will talk about some of the nature of the process itself, which will indicate or debunk such misconception. Usually we have two main types of dispute boards, which is the standing dispute board and the ad hoc dispute boards. Given that the standing dispute board is the most common one, we have to understand that under this type of DBs, the standing dispute board, I always say the largest and the most important role of the standing dispute board is dispute avoidance. And dispute avoidance mechanism that the parties with the DBs follow to avoid disputes. And given that the main task, the main approach is of the standing dispute board is dispute avoidance, normally one cannot say that avoiding disputes favors one of the parties. So, given that the main most important task of DBs in the standing dispute board is to avoid disputes, this negates the misconception that dispute boards favors the contractor or one party against the other. If we turn to the practice of dispute boards, again, with the practice, with the studies done to analyze these practices, again, this misconception is debunked or negated. A study was carried out by DRBF back in 2018 in the Asia region, and this study gives results, and all these results show that DBs actually not favor contractors, but they favor the project. The first of these results is that 95% of the parties prefer dispute avoidance process. This means that both the contractor and the employer agree on the process of dispute avoidance, whereby the parties agree to refer something in conflict between them to the DB, asking for an opinion, which we call a non-binding opinion, and these issues are resolved at this level. One of the results also is that when dispute avoidance is practiced, the probability of an issue ending up in arbitration is very low, at a rate of 6%. The third result is that of 337 DB advisory opinion, only 7% went to a formal DB referral. All these statistics show that the two parties, the contractor and the employer, agreed to refer something, to refer an issue, a conflict, to the DB, asking for a non-binding opinion, and most of these issues are resolved at this level of non-binding opinion. So the DB issues a non-binding opinion, which is accepted by both the employer and the contractor. Again, if there is any such misconception that DBs favor contractors, we would have seen many of these issues raised for dispute for a decision, dispute court for a decision, or even for raised for arbitration. But this was not the case. We go forward with these results of the study, and we see that of 512 DB decisions, only 6% were referred to arbitration. Again, these numbers shows without any doubt that almost all the decisions are accepted by both parties, except for these 6%. So we have 94% of the decisions are accepted. This is against any misconception to say that this favors the contractor. Again, only 7 of this 6% were ultimately overturned by arbitration decisions. Again, a small portion of all these decisions, when it was raised to arbitration, only 7 of the 6% decisions were overturned, and arbitration was opposite or against the decision rendered by the dispute court. The last of these results is that the dispute court process had a success rate of 94% in avoiding extensive follow-on dispute litigations. This means that both parties, the contractor and the employer, are satisfied with the decision rendered by the DB. If this would mean anything, this would mean that there is no such misconception that DBs favor contractors. Simply because most of these disputes are resolved, are ended, are settled at the DB process. Thank you.
Very good. Thank you so much for that presentation. We'll now move on to the fourth and final misconception, and then we'll move into questions. We have a lot of great questions coming in from the attendees. If you have something you'd like them to address, be sure to include it in the Q&A window, and we'll get to those after we hear from Yasmin Chantanel about some of the legal aspects of dispute boards in the MENA region.
Hello, everyone. Thanks, Anne. And all of the 3 presentations were great, and I'm conscious of time, so I shall be as quick as possible. So the question of enforceability and whether or not dispute boards are really having a jurisdiction is a very common question, and unfortunately there have been numerous occasions I had to answer it from the same perspective. So I will try to analyze the question and the answer as well in this speech. So when the question is addressed, it is more or less in this way. Okay, all you are saying is very good, but dispute board decisions are not enforceable. So what use do we have on dispute boards? And okay, so at that point, the important issue, I think, is to convey what the dispute board really is to the other party, because enforceability is only a very small part of the whole concept. As Tariq's presentation was very well demonstrating with numbers, we are talking about 7% of a 6% in numbers of the whole dispute board referrals, informal or formal. So therefore, the first message from me is that if we know very well the concept, we use the concept efficiently, the enforceability should not be an issue, and here is why. The pure legalistic approach, if you want me to reply the question as whether or not we can take the dispute board decision and go to an execution office and put it into what we call execution phase, we cannot do that. They are not court decisions, they are not arbitral awards. Well, they don't pretend to be actually arbitral awards or court decisions. They are contractual mechanisms, they are contractual creatures, as Walid has put very correctly earlier on. And indeed, at the start, at the outset of this concept in US, they started as not even dispute board decisions. They started as a mechanism which provided recommendations to the parties. So it was all at a non-enforceable manner and even non-binding manner in any event. So it aimed at strengthening the parties' relations, and it aimed at providing the parties a strong support with experienced and expert people. Therefore, the second aspect and message would be that they never intended to be enforceable and or executable processes. In this perspective, I admit that there is a different approach between common law systems and civil law systems, because under the common law system, and as we probably all know the famous Persero case, they do actually have an interim enforcement, a provisional enforcement nature, which under civil law jurisdictions, we certainly do not have. So there is a difference in the legalistic approaches between continental and common law systems. But again, we do not intend to replace arbitration or court cases anyhow. So how do we efficiently use the nature of the dispute boards in order to have a practicably enforceable decision and or recommendation in our hands? It's not very difficult indeed. So when I look at the region, MENA region, and where I come from is actually part of the MENA region, so I'm comfortable in evaluating the region itself. I see that, and I now refer to the Arcadis report of 2018, 19, and 2020. The concept itself is not unknown. So we know that, for example, when you look at the slide here in 2018 report, the Dispute Adjudication Board was in the 3rd rank within the most common methods of alternative dispute resolution. Then it disappears. It is replaced by mediation. So my take from this is that we know the concept. We are not good at using or promoting it. and hence actually the reasoning of this webinar. And hopefully it will be repeated and it will lead to an establishment of a more shared knowledge on the concept itself. So we did still not recognize the concept. Then I would like to refer to the local dynamics, the regional dynamics, and if you could please move forward to the other slide. This is a table which I find very useful when I evaluate the alternative dispute resolution methods and to understand why the MENA region is having a different approach than the rest of the world, or let's say than the Western model that we are most of us are used to when we resort to this kind of ADR methods. I'm not going to repeat the table, but what I take from this table is that in this region, we have some very important concepts that we can actually use when we are trying to establish and or make any ADR methods enforceable in practice. What are these? For me, first, respect. Second, probably having good at its job and being an expert, let's say. And third, should be good faith. And I refer to Walid in that, and good faith is in our civil codes actually, is a codified nature and concept. So using these three very basic concepts, we should be able to make, now I'm turning to dispute board concept itself, make the dispute board process very well functioning. Why is that? Because in a dispute board process, you have one or three very knowledgeable, very respectable people, expert in their jobs. And what I usually say when I try to promote the dispute board concepts to newcomers is the fact that, believe it or not, these people that you will be appointing and will be conducting the dispute board process will be in one way or the other as experts or as arbitrators in the arbitration stage in front of you in any event. So you should make good use of this, rather uncostly, rather unlengthy procedure and solve your problem, even avoid your problem at the project level. Therefore, and as members of MENA region, we should think that because the respect and good faith is in our veins in any event, and if a dispute board process is conducted very professionally, that we have the respect toward the dispute board members, the outcome of this process should be a very respectable decision and or recommendation. So we should use the outcome in order to make two things, whether to use it in our amicable settlement negotiations with the other party, thinking and knowing that this result in your hands is not going to radically change if you go to one step further and go to arbitration or to your court case. And try to settle in line with your traditional culture, because amicable settlement is in our traditional culture. In Turkish, it's sulh. I think it's coming from Arabic in any event. So you can use primarily the recommendation, informal advice, or decisions in your amicable settlement negotiations, and that's it. Secondly, for the governmental authorities, and I think there was a question along those lines. Of course, in construction projects, especially in this region, the employer part, the client part, is usually governmental authorities. And I take that, I firmly believe that the dispute board recommendation or decision or informal advice may be a very good tool for the employer representatives, employer officials to use in their internal structure, because of course we are all aware that in order to any governmental entity to give any decision, they have to go into multi-layer decision-making procedure within their own organization. So a decision or recommendation in their you know, dossier as a backup to try is a perfect tool in our process and decision or recommendation enforcement. So overall, I conclude always the same manner. If we conduct the process professionally, in accordance with our code of ethics, you know, by respectable and knowledgeable dispute board members, the enforceability in practice should be very easy, and you know, the of course, for establishing the legal background and codification is also another step we should be taking, but until we go there, we should be able to solve it before resorting to arbitration or court cases in any event. And with that, I shall be finishing my speech. Thank you very much.
Very good. Thank you so much, Yasmin. While you were presenting, we did have a couple of questions come in that were specific to your presentation. So I'd like to go ahead and tee those up if you don't mind. And we are moving into our Q&A portion of the webinar. So we will try to get to all of the questions, even if we end up needing to run a little bit over. So if you all have a question you've not answered, please pop it into the Q&A field. And I want to resolve one question that I've received multiple times. We will make this presentation available to you all, including the recording link and some other resources that we think might be useful to you based on the questions that have come up throughout this presentation. So Yasmin, the legal questions that were brought up, one person would like you to explain more on the triadic structure that you referenced. And then also someone asked about how the local courts in MENA react to the decisions of dispute boards. So if you could touch on both of those a little bit more, I'd appreciate it.
Yes, of course. For the first question, perhaps I should take some more time because it's not exactly a legal question. It's more a cultural question. Sure. To compare it with the Western way of looking at ADR methods. But the last question, yes. So very briefly to put, when a dispute board decision is made, of course, there is two ways. You either give a notice of dissatisfaction within the term specified in the contract, usually 28 days, or you don't. In the case where none of the parties give any notice of dissatisfaction, the decision becomes something and final and binding. And I should state my own country's regulation in this issue. It is different than only binding dispute board decisions, which remain at a contractual level. So they, in order to enforce the other party who doesn't comply with it, the next action should always be to resort to the next level of dispute resolution mechanism, which is usually the arbitration. But when at the first stage you have a and final and binding dispute board decision, under Turkish law, there is a specific civil procedural contract type that in theory, you should be able to put it into execution. It's very specific for Turkish law. But again, it changes the nature of the dispute board decision from contractual to civil procedural law nature. So you can use that tool, and there may be some nuances in other civil law jurisdictions, but this is something specific under Turkish law. That said, so far I almost never encountered a dispute board decision which became final and binding at the same time. Okay, sometimes only time extension decisions, but definitely not no decisions in relation with any compensation or monetary nature. So when you have only a binding decision, there is no way that you can resort to your local execution offices. You have to go to arbitration first. And in arbitration, you have two methods. Either you don't make use of the board decisions and by way of requesting an enforcement of the binding board decision at first sight as a preliminary matter, and you go to the merits directly, whereby your arbitrator will open up all the merits of the case, and you have to wait until the end of the case in order to have an arbitral award which is enforceable in nature. So if you don't divide the case into two, you are waiting until the end of the arbitral proceedings. If you divide the case into two, you have to ask for an interim award for a provisional enforcement of the binding dispute board decision. And the arbitral tribunal, of course, could grant that if they think that procedurally everything was correct. Without going into the merits, they can proceed with an interim provisional order decision. That said, an interim award under civil law jurisdictions is very difficult to enforce, if not impossible. Coming from Turkey, under Turkish law, you can only enforce final awards, be it partial, be it final, I mean at the end of the proceedings. So if a Turkish court encountered a request for an enforcement of an interim arbitral award, the other party will easily say and state the relevant provisions of the code, saying that you cannot enforce it because in order to enforce any arbitral award, you have to have finality on the dispute. So unfortunately, if you go that way, under civil law jurisdictions, most of the civil law jurisdictions, you will not have any good chance of enforcing it at an earlier stage.
All right, very good. I'm going to cue the next question up for Waleed. This goes back to the topic of a sense of fairness. So the question reads, DRBF makes it clear that we consider it to be not to be their prerogative to apply their own sense of fairness, but is that also the position of FDIC contracts? So could you comment on that, please?
I believe it is the position of FDIC contracts as well. However, FDIC contracts do not have an explicit provision that they must follow the wording of the contract per se. As you can imagine, the first case that I mentioned when I said that I became an anti-dispute board, I was looking all through the contract to find this clause. You know, like, so this can't be happening. They have to have violated a certain FDIC provision or something. I could not find such a provision. So I think it should go without saying, but there is not. So I would say the answer to this question is yes. This applies to FDIC contracts as well. However, it is not explicitly mentioned in the 1999 contract, at least in as clear as the DRBF is mentioned. Actually, I could just mention as a quick note, when we issued a notice of dissatisfaction to that decision, the response was that, you know, look at the FDIC, it's called the procedural rules at the end of the contract. It says that the dispute board, their decision is really ultimate. So this is the final decision. So that's what matters. And so that's why it gave me a bad, had a bitter feeling. But so the answer to the question, I believe, is yes, but it's not as explicitly mentioned in the DRBF.
All right, very good. We had a few questions about statistics. So someone asked about statistics of dispute board use in North Africa. Another asked specifically about Egypt. And then someone asked if dispute boards are being used in the UAE, a yes or no question. I want to mention that the DRBF does have a database where we try to track projects worldwide. It's downloadable as an Excel spreadsheet off of our website. We have over 2,800 projects listed there. The challenge for us is that we are reliant on people reporting to us about dispute boards. And that is a difficult thing to gather. Some cite concerns about confidentiality in the contracts that they've signed. They don't even want to acknowledge that the dispute board exists on a project without getting clarification from the parties. And so it is an ongoing challenge for us to track this data. We have gone through a study working with another International Contractors Association, EIC, a couple of years ago, and that gave us some useful statistics. So we're not ever going to be able to give you a 100% answer of every board that exists, but of course, when you're working in this space, often people do know anecdotally. So I'll just turn it over here. I don't know, Tarek, you covered some statistics. Mohammed, you did as well. Would one of you like to just comment specifically on the use of dispute boards in UAE, Northern Africa, and Egypt specifically? And if there's anything notable that you'd like to say about those statistics.
I can say something about this. Yes, it has been actually used in the North Africa and in some countries, in some projects. Not much, but mainly these are the big, huge projects which are run by government or by big investment funds or by the whatever is done through the World Bank developments. So these are all had used the dispute boards. You might, I'm sure there is something in Egypt as well, but it's not known to the practitioners because it is either the employer is the development bank, so it's not through the normal rules or procurement rules that goes in the country. In Libya as well, in Sudan, I know as well. So in UAE, I'm not sure if there is something there, but in other countries, yes, there is in Bahrain, there is in Bahrain, I know, in Morocco as well. So it's not, there is no big statistics coming up, but there are things that are already listed in our website, but not everything, and that's a good guide to start.
Very good, thank you. We do have some questions that are related to sort of dispute board best practice. So one is a question about whether attorneys commonly serve as dispute board members. I see Yasmin smiling. She's heard this question before, so perhaps you can field this one. And there's also something I think is sort of related because it is about the composition of the board. It's a question about whether it's better to have a sole dispute board member or a 3-member panel. So could you comment on those two for us, Yasmin?
Of course. Okay, yes, this is another common question we come across too. And yes, the lawyers are also appointed regularly for dispute board member rules. That said, if it's only a sole dispute board establishment, we usually note that engineers take that position as opposed to lawyers because the majority of the issues may relate to technical issues rather than a legalistic being legalistic in nature. However, in dispute boards composed of 3 members, we always advise to have a lawyer involved in order to have coherent and lawful, let's say, decisions in accordance with the governing law of the contract, which may be better with a touch of the lawyer in the board itself. Of course, I personally note that a pure legalistic approach will not work even if you are a dispute board member. I will say lawyers who are appointed regularly for dispute board roles are very used to this process and shall be very used to this process and should be flexible, practical, and project friendly rather than litigation friendly in nature. And there is a huge difference when a lawyer who is not well experienced in dispute board process and who is rather a litigation lawyer, be it arbitration or court proceedings, the conduct of the board changes radically. So it may not be the best practice to apply the litigation concepts towards the dispute board process.
Very good, thank you. There are 2 other questions about serving as a dispute board member, which I'll just address very briefly. One is whether the DRBF has published rates for dispute board members. The short answer is no. The longer answer is we do have a full chapter on costs and fees in our manual. Waleed mentioned the manual at the beginning, and we will include a link to that resource in the email that goes to you after this webinar. So be sure to read that. It does have some models for figuring out how to project the price of your dispute board, and it does talk about common rates that are used worldwide. They do vary in different regions. The other question was how to get an appointment, how to serve as a dispute board member, and this is also a popular question. So popular, we will be having a webinar on this topic next month. So you are now on our mailing list, and we will be sure to send you a link to follow that. Step number 1 is always to complete DRBF training, and you will get information about our training programs as well. So those are good ways to get started on dispute board service. Now I'm going to turn a question over to Tarek. You commented on the misperception that dispute boards favor contractors, and one of our participants would like you to comment on whether or not DB decisions may favor the employers, since that is the source of the work. So could you comment on that for us, please?
Yes. The short answer is no. DBs will not favor employer. As we said, DBs favor the projects. They follow the contracts. They follow the provisions of the contract in order to apply all and every in the contract to the case raised to the deed. And I want to add from my personal experience, I have participated in many boards either as a counsel or as a dispute member, and currently I am involved in 3 cases. Either as a counsel or as a dispute member, and in all my experience in this field goes with the answer that dispute boards favor the project. Thank you.
Thank you very much. This next question is another common misperception, so I'll just read it in its entirety. A misconception of many project owners, especially governmental project owners, is that they would lose part of their control and leverage to negotiate and/or decide. Also, the DB may not align with their project governance systems. So how would the panelists respond, and what suggestions would you offer to make the DB practice adopted in the governmental sector which represents the major share of construction in the MENA region. So who would like to tackle that one? Yasmin has her hand up.
I mean, sorry, if anyone else, of course, please feel free to join. It's just that part of, in a part of my speech, I actually addressed that issue as a recommendation rather than an opinion, of course. I believe that, yes, this is another misperception, but perhaps strengthening the idea and use of the informal advice process with the dispute boards may actually be a very good tool in order the governmental bodies to get used to the idea of taking the opinion of an expert which is appointed as a dispute board member in their project. So they will have only a non-binding recommendation in their hands, but which is an indication, nevertheless, towards the formal side of the dispute. So they can start with that. They can start with the informal advice that the dispute board gives, and they will simply say, okay, this has no binding effect, but we can have, we can take a lesson from that, and why don't we try to settle with them perhaps more positively, rather than just coming to the table, listening, and just living away without any positive negotiation. So informal advice may be one tool. And second tool should be, in my opinion, the awareness that these dispute board members are practitioners, experts in their fields. So more or less, the tendency will be similar in any arbitration or court proceedings. So we should be aware of this fact, and we should be treating the decision or recommendation accordingly, so that when we are talking with our supervisor or with the decision maker at the end of the hierarchical, at the end of the department, we should be explaining them that yes, we can of course resist, we cannot comply with the decision, and we can perhaps take them to the court or arbitration, but we should be aware that the result may not be that radically different at the end of the arbitration, and to see that and to save a whole arbitration cost as of now may be a prudent practice, even for us, the governmental entity owners. So the internal recommendation may be given in that manner to strengthen the idea. I will give you an example from Turkey. In a very major infrastructure project, a dispute board was used with over 60 referrals, if I remember correctly. And the engineer of the project, at the end of the project, issued a report to the employer, basically stating that without the dispute boards, they would most definitely be ending in arbitration, which will cost to the parties, perhaps cost to the project as well, because project could have stopped, the contractor could have been bankrupt because it's really, really major infrastructure. So these are all indicators for the governmental entity and lessons learned for other projects to be used to say that, okay, let's trust these guys and let's try to negotiate over the dispute board decision or recommendation.
Very good. Thank you, Yasmin. All right, we have another question for Waleed. Yes, did you want to comment on that as well, Waleed?
Yeah, just two quick points. From my experience, I've been involved in two, like you could say, important governmental projects. One of them is the high-profile project that I mentioned. A lot of government employees, when they're in these kinds of projects, they're very reluctant to make any decisions, very reluctant to enforce these dispute board decisions. And so there's resistance at first until they realize, as Yasmin mentioned, there's a hierarchy. So when they realize that, okay, they have an excuse, which is, to their managers by saying, okay, this is the contract requires dispute boards. And as Muhammad mentioned, and this is very important, a lot of projects, from my experience at least, owners do not voluntarily go with dispute boards. What happens is that the World Bank or the JICA, they impose, this dispute boards because they impose FDIC contracts, and this is why you have dispute boards in the MENA region for most projects. I will not say for all projects, but then, so this government employee says, well, this is a JICA contract. It has FDIC and it requires a dispute board, and the dispute board made a decision that is binding. So this is my excuse. It's not my problem for enforcing this dispute board decision. So this is an important, I think, a point that I wanted to mention.
Very good, thank you. We did have a question specifically for you. So it notes that some DABs seem to overly rely on legal expertise and allow certain laws to supersede the express provisions of the contract agreed amendments in deciding disputes. But it looks like in Egypt, this is actually encouraged or to be expected based on Article 148. So could you comment on that, Waleed?
Yes, that is correct. Not just in Egypt, but I think the MENA region as a whole. And this is the reason for that is when you look at the civil codes, there are the provisions within the civil code can be classified into two things. There's mandatory provisions that would supersede any contract provisions, and there are, you can say, permissible provisions. They run alongside the contract, but they would not supersede the contracts. And so you find in a lot of civil code provisions, there is reference that says that this provision supersedes any agreement of the parties to the contrary, for example. So we know that this one is non-negotiable. A good faith is one of those mandatory provisions. So that's very true. But I think if I would add a twist to this question, which is if there's a case in front of the dispute board, a referral, and one of the parties does not refer to a certain legal reference, can the dispute board make a new argument and refer to it? And so say that the dispute board members know that there's a legal reference that the parties did not refer to. Can they raise this new argument to reject a claim or to approve a claim? I think that's a question that I would think I'll leave unanswered. I don't think there's a specific response to that, but the short answer to your question is yes. Dispute boards can rely on these mandatory legal provisions in their decisions, yes.
All right, very good. We do have a question about seeking an understanding about the reasons for reduced usage of the DB process in MENA from 2017 to date and how this trend can be reversed. So who would like to comment on that?
I don't have an answer, but I just could note that the report itself does not indicate why. So,
hard to say. Waleed, did you want to comment on it as well?
Yeah, I would suggest that there is a lot of owners do not want to use dispute boards because it's in the MENA region, FDIC contracts are very popular, and in the FDIC contract, the type of dispute board is an adjudication board, so they make decisions. And I think in the Middle East, there's resistance to these decisions. As one of the questions they mentioned that, maybe owners would think, that dispute board making decisions, that's taking away from the owner's leverage. But as Yasmin mentioned, and this is a very critical component, and I think we should be enforcing this in a lot of, addressing this in other webinars, is there's dispute review boards. They will make non-binding recommendations. They would facilitate the party's ability to negotiate, and they're experts in the field that can provide advice, not a decision. And so with that, I think that would maybe result in the widespread use of dispute boards, for example. So DRBs are popular in North America, not in the MENA region, but what if they are used in the MENA region? I think that would maybe result in an abundant use of dispute boards. And by the way, in the FDIC contracts, there is this provision for an opinion, a non-binding opinion, which is not that used, that's not that commonly used. And of course, as we know, in the FDIC 2017 contract, there's this avoidance factor, which Dr. Tariq mentioned, which also, I think when the practitioners in the MENA region are aware of this non-binding opinion recommendations, then that would result in a widespread use of dispute boards. But currently it's this adjudication factor, this decision factor that is maybe causing this resistance and low use of dispute boards, I think, in my opinion.
I think that's a great point. I think it's often an underappreciated distinction about the dispute board process, that it actively promotes dispute avoidance and resolution at that very informal low level. And that's the real beauty of the process. When you talk about statistics, our best statistic is a project that had a dispute board on it, and we have no data to tell you about the number of issues addressed and how it was resolved, because everything was resolved without going to a formal hearing. So those do exist out there in the world, and that is a real benefit of the process. We do have a question about whether there's any experience with IFC investment. I don't know if any of the panelists have any experience with IFC investment, so I'll tee that up. No? All right. Well, we'll move on to another question. This one is about should the DB put into consideration the repercussions of one of the parties after the ruling to avoid following acts that could arise from such dispute, for example, in government-issued contracts, or should it focus only on contract-related topics? Who would like to field that one? Any comments?
Can you
on
rephrase
that?
the question again, Anne?
Sure. Should the DB put into consideration the repercussions of one of the parties after the ruling to avoid following acts that could arise from such dispute? In parentheses, for example, in governmental issued contracts? Or should it focus only on contract-related topics?
If I can answer this, and I would think that they should most definitely focus on the contract provisions without thinking of repercussions, because as we've mentioned, the dispute board is just a creature of the contract. Should they think of repercussions which make them not enforce the contract provisions, and in essence, they have violated their primary obligation, because they are there to adjudicate or advise on disputes in accordance with what the parties have agreed to. They cannot think of other factors and repercussions. And again, this is like the misconception that I have addressed. So instead of fairness and equity, even if if we replace that with repercussions, for example, that's the same thing. You cannot ignore the contract provisions. You must go with what the parties have agreed to. So I think this is my opinion.
All right, very good. I know this session is running long, but it's wonderful that we had so many great questions from participants. I'd like just to field one or two more if you guys don't mind staying on. One is about member selection. Can the parties comment on the damage that a party can do by appointing a biased member? Now, one little distinction I'd like to make here is that the DRBF does recommend joint selection as a best practice. In this case, both parties would equally be choosing the board members, so there is no concern about the party's appointee. The idea is to help offset that misconception about panelists having biases towards the project owner or the contractor. But nonetheless, I think issues continue about the fear of appointing a biased member or discovering bias as the project is underway and the board members are serving. So would one of the panelists like to comment about that issue of bias amongst the dispute board panelists?
Well,
And I think the question also is what parties can do to ensure that they are rigorously selecting their panel members.
Well, I think the DB members should have a lot of characteristics and qualifications and reputation as well of being of how they have acted before in other projects as DBs. Of course, if there is a tripartite agreement which every member has to sign with the two parties as well. So if he's biased, then the party who's getting the damage, he can always, you know, have a sort of a claim against him, and he can, and at the same time, they can easily, you know, oppose his existence or her existence in the DB, which is cannot be you know, ignored by the other party if the reasons are valid. So of course this is not a usual way to have a biased member. Of course, with the biased member, then we don't have a real action and activity of the procedure of the DP. Plus, it is always there is a way of getting rid of this biased member.
Very good, thank you. Well, most of the remaining questions I think have been covered in some capacity, although there might be some nuance and distinctions that weren't. We'll do our best to cover those in our follow-up email to you all, or we will include contact information for all of our panelists, and you are invited to engage with them directly to get further input and insight about the use of dispute boards in the MENA region. I'd like to conclude this webinar by thanking all of our panelists for their time and expertise in sharing their experiences with dispute boards in the MENA region with you all. I'll just reiterate that we will be sending you some follow-up information after this presentation, probably in the days ahead. We have a couple of resources, not only the recording from today and the presentation, but also some other links to DRBF materials. For example, we do have a link to our manual, which is a free download, and I referenced that earlier for the rates and fees and other questions that have been posed today. So that'll be a great resource for you. The DRBF will be publishing a best practice guidelines for the use of virtual dispute board proceedings. This is something that has been a bit of a hot topic in our community since we've been dealing with the global pandemic and are having to switch some of our work product online, like today's webinar. So we'll have that resource coming out. We also have a webinar on this topic coming up this Tuesday. So check the DRBF's website or your email for information about registering for that webinar and joining us on Tuesday. And I thank you all for staying with us to the end of this webinar. We're very pleased to have your interest and participation, and we look forward to seeing you again in the days ahead. Thank you.
Thank you all.
Thank you.
Thank you. Thank you all. Thank you.